expert
Yeah,
testimony.
if it's a
Can't do it
serum,
any other way.
But yes, you can, that, right.
Right, because it's taken for medical
They
purposes.
said that doesn't come under the consent thing
And it
because it's a
presumes,
hospital record.
it presumes accuracy.
They're allowed to use it and get the presumption and argue that it's a .21.
Sergeant's in here, by the way, in your material.
Yeah, Sergeant's in there. That was Pat's case. That's where that was first decided. Although the hospital record issue, as Dick mentioned, I think is a live issue too. There's definitely conflicting rights involved in hospital records.
I'll tell you, if a
We
DA
put out
tries...
subpoenas, you know, all the time, and now hospitals have been informed by their counsel not to honor subpoenas, and they write saying they want a court order. And there was a Superior Court case where where the judge said, "That's right, that you can't just subpoena hospital records. It's going to go up one day because there are very clear rights, especially in Massachusetts, with privacy, confidentiality, and there's also rights to get evidence of criminal cases, and those sometimes conflict." So, I mean, I'd say that's a live issue in various areas as well. Nobody's resolved it entirely.
Yes, sir.
So, have you heard of a drink that's called Long Island iced tea?
Yeah, it's every kind of, I know what it is. It's every kind of white liquor, gin, vodka. Most bars won't serve them in Massachusetts.
Yeah, I don't know what's in it.
I'll tell you what's in it. It's gin, vodka, rum, and there's tequila, and some of these people, and a little bit of Coke. Looks like
Sounds
tea.
great, yeah.
Let me ask you this. Let's assume that there is such a drink known as Long Island iced tea, which is an incredibly powerful drink, but which tastes just like iced tea.
Tastes like Coca-Cola.
Okay, now let's say that I represent a young woman who's 22 years old and is basically wondering a very light drink. And she's at a party and the guy's trying to pick her up, serves her a couple of Long Island iced teas. He comes on a little strong after about an hour and a half. She wants to get out of there. Now this is not a real case, but I'm just giving this to her. She wants to get out of there and she leaves the party. She gets in her car and she drives home and she's hit with the effects of this thing. She gets pulled over, she takes the breathalyzer, she fails it with a .13, and I come to you and I say, Joe, I'm going to say the off the record, admittedly, she had too much to drink, she wasn't able to operate safely, but she didn't know that she was getting drunk. And she didn't know, so she did not have the criminal intent. That's a little bit different from Dick's statement of, yeah, when someone forces it down, you know, it forces it down. In this case,
So it's fraudulently
She didn't know she was drinking.
Okay.
No, yeah, she didn't
That's a
know.
defense.
yeah.
Right, he's going to talk about plea bargain.
Okay, so on that, would you be inclined to dismiss the case?
Let me be honest with you. I mean, on that you may find someone that I've been in too long to, you know, I've heard too many stories. Get cynical on that. And I agree with Dick. It's a great defense, and I'd say to you, Jesus, it sounds like a great defense. Let's go to trial. And maybe you'll probably win.
We'll have the jury sample it
Yeah.
all. We'll have
Now, however, if you build your case, and the guy comes in, and the parents come in, and 3 other people at the party came in, and you know everyone signs a statement that's, you know, you can get a scenario where I would go for, where everyone said we had no idea, you know, and I believed it.
serve you one of these drinks.
And I believed it, you know, sure, I'd do it then.
Massachusetts bars will not serve that drink as a dram shop will.
Yeah, sure, I'll do it if I'm actually convinced. It's just it's hard to convince me.
By the way, most of the time you're not dealing with a district attorney who has any authority to do a lot of this
Well,
stuff.
they'll come to me. They come to me and ask me. You know, I get calls all the time from the district court. Here's what the guy said, this and this and this. Can I reduce it? You know, or, I'm the guy they ask, or you think I should reduce it? We give a little more flexibility, but they still, I mean, you know, everybody's uptight about this too. And I'm the buffer. And I say, go ahead and do it. And, you know, if there's any flack from the family, this and that, sometimes I bring in the victims or something and I, you know, explain why we're doing it. You know, you got to make, I believe the DA is there to make decisions. You don't duck everything, you know, just because, you know, this is for public consumption. If I'm satisfied that it shouldn't be tried, I'll do it, absolutely. And I think anybody who doesn't do that is shirking responsibility. Now, whether another office says you have to go check it with a higher up, that's different. But I guess I am the higher up in Essex, so and I believe you do have to drop cases, absolutely. And if it doesn't look good, too bad.
Now that leads to my...
I don't have to be elected either, you know. I'm not
If you're dealing on a case where you think that the district attorney is exercising the discretion that he or she has, but you feel like Dick's case where the discretion should be exercised differently, but
Right.
that particular DA at that particular level isn't going to have the authority or
happens all the time, right?
What is your suggestion about the most practical, respectful way to climb the ladder within the district?
Well, it depends how familiar you are with the office. I have had attorneys come in, I mean, because it's known in Essex County, for example, that I review every single motor vehicle homicide. I don't handle them all. I used to handle all the felonies, and now I still do a lot of felonies, but not all of them. But I do review every single one, and the purpose of that was to get some uniformity, so that our guy in Newburyport wasn't doing this on the thing, and somebody else in, in Salem was doing something else. And I keep track of the dispositions, and I give advice and stuff too, but I let, they make up their minds. And we don't have that stringent a policy when there's no drinking even, but we do keep the records, so we have statistics and we know what's going on. I've had attorneys come in, a pre-indictment on felonies with an expert witness, and it's a risk. I mean, and Dick will have to, talk about the risk. It's a risk they take. He wants to present the case to me pre-indictment to show why it should not be a felony. Of course, the felony is a mandatory jail. If he can get out of the felony, this attorney, who's a well-respected and well-known attorney, he doesn't really care that much what the DA recommends. As long as he can get out of the mandatory, he's going to put together a disposition plea that's beautiful. The guy's an accountant, family, he'll take his chances, but he's got to get out of the mandatory. So he brought in an expert, laid out a thing with, 25 feet long with diagrams and this and that. I'm not going to do that myself. I called in the state police expert, and and we had a meeting, and in fact, he convinced me on that. And I went out to the scene and looked at it, and it's not going to happen, often. But and you take a risk, because obviously, if he's shown me his case somewhat, although we knew what the case was anyway. When you try a lot of them, after a while, Dick's going to have a few surprises, but he's going to tell basically what it is. And I know what he's going to say on cross-examination. There's no way I can do anything about some of the things. Some things I can, some I can't. It's not a surprise ambush type thing usually. And with the homicides and negligence, same thing. It's like tort cases. I can't tell you that. In our office, the attorneys all know that indictments are all reviewed by two people. So that the district court DAs do not decide which cases go to probable cause hearing even, or which ones get indicted, or which ones get broken down. And it's known who, it's not a secret, or you tell anybody who the two people are who review it all and then send the messages back down to the district court people. So they get the calls directly from the attorneys who deal with our office all the time. Nobody, and in fact, the DAs in the district court tell them, hey, call so-and-so, call Green on that one, If he says, okay, good, I don't care. But I don't know, and maybe other people have other experience in how to deal with that. Yeah, you can't do it like if it's a new DA who's really uptight, has an ego problem, and you're going to go insult him by make an appointment with the first assistant. I don't know. You don't bother with that anyway. We bargain for it.
So occasionally, I'll have something that's important. For instance, and sometimes it's almost as bad as the mandatory. I had a pilot. Needless to say to you that a conviction, even with the program, even continue without a finding, we would have to admit sufficient facts. Goodbye. His career is over. And there was compelling reasons why the case should have been dealt down, other than it was a pilot. I mean, it was a weak case. And this particular guy is very conscious of alcohol consumption because it's his whole career. And it's his ticket. And I was able, fortunately, to convince the police. And then once I convinced the police, I let them do my bidding for me with the DA. And I had to take a chance there, because they can always, and if I thought the cops weren't sincere, the easiest thing in the world for them to say, oh, the DA wouldn't do it. Mm-hmm. But I sat in the office, I talked to the chief. I said, look, how do we do this? You tell me, you deal with these guys every day. If I went, it sounds like just another lawyer making a pitch. You do it. So he sat and called the district attorney of the county and asked, would he mind if this could be done, and very respectfully and all that other business. So all the egos were massaged. And I said, find the guy anything you want, court costs, up the wazoo, anything you want to do. But the bottom line was, as is in these vehicular homicide cases, to avoid the mandatory, was to avoid any implication of a conviction involving an alcohol-related offense. And you have to sometimes. I mean, in those circumstances, come hat in hand. And I put together as much information And my presentation to this particular chief of police was just as comprehensive as I present to a jury, because I know that it would have been it's a much harder sell than to a jury.
And as Dick said all along, right from day one, the very first thing, you've got to make your case different from all the other cases. And you know that everyone hears stories every day. So if
And
you
one
can
of the
do
ways,
that,
by
but
the
it
way,
can be done, you know.
let me tell you how some of the things that you can do to make your case different. Agree to meet the DA in the afternoon when things are quiet,
Exactly.
rather than when there are 40 lawyers around, okay? That tells the
See,
DA a
they're all
couple of
nodding.
messages.
All the DAs are saying,
Sure.
that's right. Yeah.
If you think enough of your client to get away from your busy office where you can make money, I make all my money in my office. I don't make money in front of juries. I make money in my office. And if I can, I could talk to insurance adjusters all day and never have to go to a courtroom, and I'd be very, very happy. But if I can take my time out of my busy day, the DAs know this. They are impressed from the get-go. They don't know what the issue is. They don't know what the case is about. This must be important, where Zissin himself will come down here and spend time in my office. I don't have him come to me. I'll haul over the state.
Not on
And
the
I'll-
scheduled date with 40 other people.
That's right, and I'll sit out there, and they feel they have to be polite, they have to talk to you. And that's when I put on my charm school routine and start to hopefully convince them that this is an extraordinary case. And I say, I'll meet you anytime, anywhere, you want to do it, if it's closer to your house, I'll meet you in a restaurant, whatever's convenient for you, because this is important to me. And it's, yes,
So you just take up a pre-trial conference before the pre-trial conference?
absolutely.
Absolutely right.
Absolutely, you know something? Pretrial conferences are not conferences at all.
That's right.
All right?
Just
When they come with a bunch of
cog in the
files, they
wheel.
fill out the form, and if she says, all right, public work, yep, and reciprocal search, yep, yep, and if you start getting into that, you've got the system working against you. What you want to do is stop the parade. Just stop. There's a train. Think of it this way. It's easy to do by analogy. There's a train, and your guy is on the track, tied down, like in those old silent movies, and the train is about 50 miles away, and it's heading right there. And
reach
you
the
have to,
brakes.
you gotta get that, throw every log jam you can before that train cuts your client in half. And that's what you're trying to do. And if you know the process, you try to do that before the pretrial conference. Now, the reason why you do that is because they're not gonna go out of their way, in fact, until that morning of the pretrial conference, to even know your client's name. But when you show up and say, oh, this is the one you saw me about. Oh yeah, let's stop, pull that aside. And maybe we'll put that over for another day, and we'll work it around. And I guarantee you, if you're creative enough, you can find something unique about every case. You can't come in with the same pitch every single time. Yes.
District Court in Hampton County, the DAs are not assigned any particular cases. What happens is whatever week the conference comes up, they may split it between, they divide the piles into three.
Right.
One of them will handle it.
Now, do they have vertical prosecution? Once they take the file, is it theirs?
No, then wherever you go after that, to the new prosecutor.
That's a problem.
I'll tell you something.
Well, they do have a...
If they will talk to you about a case, more than a day before your trial, they're doing you a favor. They're doing you a big favor.
Mm-hmm.
And then, once you get to trial, you're lucky if that DA happens to be in the
Same DA,
courthouse,
yeah.
never mind in the courtroom,
Yep.
or near the courtroom.
Yep, I've been
that
faced
you
with
may
that.
deal with. And another DA is not likely to honor, if you have a good deal made, is not likely to honor that deal.
Well, there
I've
is a
been faced with
supervisor, though, in Hampton.
That's right, we do have a supervisor.
So, I
He,
mean- That's where I'd go.
actually, that's a good point.
Yeah, I mean, there's always some sort of thing you can figure out like that. If you get to the supervisor and you say, look, I know this is, out of the way for you. I know you don't assign the cases till, up there, and I understand, but, like Dick said, can you give me, you know me, I'm here all the time.
I'm not
Can you give
asking
me
for them to
can you
do
give
me a
just
favor on the case because of any relationship they have with me.
But just give me some time.
Just give me time, just listen to me.
Yeah.
Let me get down on my knees and sing Mammy to you. That's basically what I'm saying for.
Yeah, if you get Wendell, man, do you know the supervisor?
I don't know, I don't even know what Hampden County is. You gotta understand, I never knew the state was this big until I drove out here.
Now, on that one, I would not go to the DA. Maddie, you're right here. But, I mean,
understand-
eventually, there's something in the beginning maybe you're uptight, but I mean, eventually, and maybe I'm being naive, and, Dick has the DAs out to be one thing, but nobody wants to feel they're just a cog and a technocrat. I mean, everybody has some sort of thing they're trying to do a job as a human being, and if you can find that string to pull somehow without being, know, I think the former DAs here will say the same thing. I mean, if all I'm doing as a job is filling out papers and not dealing with any human beings or just doing my thing like a machine, you know, that's not much of a job. You know, nobody wants to think they're doing it that way, if in fact they are doing it that way.
By the way, I have to say, in defense of this other fellow who went back on the deal because he didn't have the authority, I felt terrible for him. I really did.
Yeah, sure.
Because here's this guy strutting around court, standing up for the Commonwealth on dozens of cases every day,
terrible, yeah.
and now he shows a little initiative, and I thought appropriate initiative. He did the right thing. He had a lot of courage in what he does, especially that office. I don't have to tell you about Middlesex. In that office, and he got shot down for it, and he says, and then when I told him about the not guilty, I saw him the next day on another case. I said, by the way, what'd they say when you got back to the office? He said, I haven't told them yet. He says, they can't beat on me if they don't know. And they got so many cases, they're not going to find out for a month. Okay, yes, sir.
Sometimes I've found that in order to resolve cases, even if it's a tort case or something, you have to give the other side a way out. You have
Right.
to
Yep.
give them something to
That's-
hang their hat on. And in cases like these where there is so much information that is needed from experts like Pat, I was thinking it might make sense for me to say to you, Joe, let's have my expert, Pat, talk with your expert, so-and-so, and let's have the experts guide us on that after the experts talk with one another. Pat, do you talk with the state's experts very often, directly? You've got a set of facts, they've got a set of facts, you deal with them, and the experts kind of help the attorney solve the case prior to trial. Does that happen very often?
Very rarely.
Because we're usually not talking facts. That's the problem, as Dick said.
Yeah, we're generally looking at some evidentiary type of problem or potential problem, and it's generally a weighted problem as opposed to hard and fast facts. I've talked to Nancy Murphy on many, many occasions, and I've talked to other people. One of the problems I have in the Commonwealth is talking to district attorneys. There are a number of assistant district attorneys out there who view me as a guy that has a set of horns and I'm an SOB. When I come in, I'm treated like dirt in most of the courthouses. Literally.
True.
Yeah, I'm a scab, as far as they're concerned. Police officers have told me if they ever catch me driving through their town, they're going to throw the key away.
They take it very personal, and I don't understand it, really.
Unbelievable.
Very
I
personal.
think, I think part of it is that people aren't experienced. And when something you're not familiar with, you're afraid of. And when you're afraid of it, you tend to be antagonistic toward it.
Well, you got to
I mean,
understand.
after you've been through several things, I know what he's going to say, and I know what I'm going to say, and maybe he'll win, maybe he won't, depending on the weight attached to the things that he says.
Like, I have a problem with that whole process that the police go through in doing their investigation, formulating these cases. Until they've been around a while, these new kids who come on and they're all bright and bushy-tailed from the academy, they want to do it right, but they get these attitudes from these older people, and the next thing you know, it's you against them, and it's the enemy and all this other business, and you talk to these cops, and some of the things they say are just outrageous, frightening. It's absolutely frightening. These people walk around with guns. Absolutely frightening.
But I think the DAs are the enemies, too. You're gonna have...
It's crazy. I mean, that's right. If the DA makes a deal, the cops say he did it again. That guy should go to the can and do all this other stuff. And I understand they have a tough job. I'm very aware of their job, having been on that job myself a long, long time ago. And I can say unequivocally that they should go to some kind of charm school or some kind of diplomacy school, because their attitude stinks. They look at these cases as bounty hunting. They really do. They're subtly encouraged to make the pinches and get the numbers up, and it really makes no difference whether or not they have that good a case. They'll stretch a little to make sure that they get the conviction rate, and it's a box score. And I've translated that to juries quite a bit. Why is that officer still in the courtroom while I'm arguing my final argument, ladies and gentlemen, if he's really not interested in the outcome of this case? If he's supposed to be objective as a Commonwealth's witness and pull that objectivity, he's sitting right over there. Why do you think he's still here? He wants to know what happened in this case. Sure, he's interested. And you can object like hell, but it's proper argument.
I told him to stay, Your Honor.
It's And you know what? And if he's not there, you know what you say? He was so concerned and sincere on this stand. Where is he? Where is he? You don't see him here.
Now you know. Now you see why they get that attitude.
Yes, sir.
Hanging around. What do you do with a district attorney who, in his summation, doesn't pay any attention to the facts? I mean, sometimes I've heard some of the district attorneys, and they had one in Essex County some years ago, a girl named Ketchum, that she paid no attention
I know
to
who
the
it
facts.
is, yeah. But that was her problem. She had a, I felt sorry for her. I mean, she was not.
You try to, you interrupt.
Well, you have to be careful of that. You have to be careful of that. There's a conflicting strategy here. The strategy is you try not to interrupt because the judge is going to dump all over you. On the other hand, you have to protect your record, okay? And if you think it's just on inexperience and it's inadvertent and it's really not that harmful, you bite your tongue, okay? And you try to get a curative instruction. But if you think they're being slick, and you've been around long enough, you know what they're doing. You say, that's it, bench sidebar, Your Honor. And most of the time he knows, or she knows, the judge. And you won't have to have a sidebar conference. He will lay that DA out in lavender. Why? Because that DA is there every single day.
It's pretty.
It's not like you might not go to that court and try in front of a jury once every 3 or 4 months. That DA's got to start another trial that afternoon. So the judge knows the style. And if he thinks that that person is taking unfair advantage, there's nothing wrong with objecting, but you have to weigh the strategy. And the strategy is it intentional or is it inadvertent? And your experience should be able to tell you that. And I wouldn't hesitate to interrupt the final argument if it's very harmful to you, what this person is doing.
I mean, any DA and DAs do read advance sheets. I mean, the biggest things in the advance sheets are prosecutorial misconduct and improper closing argument and the jury
One of the
instructions.
biggest cases in Essex.
Yep. However, so, I think, and everybody's aware of that. We do trainings all the time. Nobody wants to lose their ticket to put a drunk driver away. And nobody's going to be there forever in that job. So, on the other hand, there may be some question of interpretation. I mean, we may disagree on what's proper or not, but there are some, and cases put them out in full detail where there's no question.
I'll tell you the risk you run as a defense attorney if you do that. In other words, misstate the facts. You can alienate the jury. Because you got to understand, the jury, this is their first case, their only case they'll probably ever sit. And they know those facts. They've heard. They can remember stuff that witnesses said that you've forgotten already, that happened only 3 hours before. They can tell you every single word collectively.
It works
okay?
the other way, too.
So if you say something intentionally, they'll pick right up on it. And now you might have lost your case because they don't like you as the lawyer, not because of the facts of the case. And that's unfortunate.
I just thought of something while they were talking about the police officer going out or not going out after the case is over. One of the things that I do as an expert is leave the courtroom after my testimony. I'm not needed in the courtroom, and that's a very important thing. And along with that, we had a case, an unfortunate situation from the defense's side, but it did happen. I was sitting at counsel table with counsel, and there was also another attorney from that same office who was sitting in back of the counsel table. And there, from time to time during the trial, there was discussion and notes that went back and forth, and the jury felt as though the prosecutor was being outnumbered 3-1 by that type of strategy. So I've made it a practice recently to ask that I not sit at counsel table unless it's imperative or bench trial. Jury trials, I try to stay away from counsel table and cut the conferences down with the attorney to a minimum. That means that counsel for the defense has to be perfectly trained before going into the courtroom about the issues and what they're going to ask for questions, etc. It means a little bit more time up front with counsel, but that preparation should be done. Try not to make it look like a mismatch.
That's why I love trying cases against the big downtown firms. They always come with 3
With
lawyers.
assistants,
Yeah, right. Sitting down.
And they write memos to
Cases.
each other and bill the
Right.
client. Okay, let me just briefly comment, because it's in your syllabus on final argument. There's one area, and I'm not going to tell you how to do a final argument, because I mean that's something that you're more than adequately prepared to do, except anticipate this argument. He's going to wince right now. The DA will always say, this is a case of who you believe. If you believe the police officer, this wonderful, charming fellow over here, you find him guilty, and if you believe that miscreant over here, the defendant, you find him not guilty. And they always come out with something like that. Now, you have first shot. DA has last shot. So it's appropriate to say the district attorney is going to get up here in a few minutes and tell you this is a case of who you believe. And he's going to say, if you believe the defendant, find him not guilty. But if you believe the police officer, you got to find him guilty. This isn't a case of who you believe. This is a case of reasonable doubt. Not who you believe. It's not a popularity contest. It's reasonable doubt. Did they prove beyond a reasonable doubt each and every element? And if you have a position consistent with guilt and a position consistent with innocence, I'm suggesting that's reasonable doubt. And these are the reasonable doubts that have been raised in this case. And I go through each one of them. And by the way, if you think of any others that I might have overlooked, add that to the list.
Feel free.
Any one of which would be enough to find this defendant not guilty. Okay, so that, something to that, and use your own words, don't use mine. But anticipate that argument, people, because it's the oldest chestnut in the world. And it's rare that I hear a lawyer anticipate and do something about it, because it's not a case of who you believe. Any questions on final argument?
Before we wrap up, I want to make just one thing. I want to especially thank Michelle, who's not in here now. Okay,
Yeah,
for putting
wonderful.
together a lot of the legal materials and the whole book. And Tony and Carol and Karen, these conferences don't just run on their own. Someone asked me yesterday, are they all like this, with the, you know, the good food and entertainment? And, they're not.
Absolutely. Suffolk is a wonderful place, those of you who might not have been here for a while.
These are the people, I'd like to give them a hand, the staff.
Tony, I think you had some announcements.
We're delighted that you all could come. And I want to thank Dick and Joe and Pat for being here and giving of their valuable time and particularly their valuable expertise. This is not my field, and I found it thoroughly engaging and entertaining, and I'd like to have rounds of applause for you guys. If you all would leave your questionnaires either outside here on the table, or there's a table at Tyler House, you can leave it there. We appreciate it. Thank you all very much. Thank you, John.
Been a pleasure. Great again. Pat, good seeing you.